Today we have a question from Sarah in Ferndale. And Sarah says, if I have to go to probate court to sell a home, how long will it take before I am allowed to sell my mother's home? And that's it, short and sweet, from Sarah in Ferndale.
She inherited a home. How long will it take to sell the home?
I'm assuming it says, if I have to go to probate court to sell a home, how long will it take before I'm allowed to sell my mother's home?
Yeah, I'm going to assume it's her mother's home, right?
Sure. Yep.
So I hate to say it depends, but let me just first qualify my statement by saying we live in unusual times right now because of the pandemic.
Sure.
And normally a probate matter with a will takes on average 4 to 6 months. Okay. These days it can take longer because the courts are backed up. Unfortunately, by the way, you're hearing these questions a lot more probate. It's indicative of what's going on out there. Okay. But in general, if there's a will, and if Sarah was named as a personal representative for her mother's estate, 9 times out of 10, the court will not have a problem giving Sarah the authority to sell the home.
Okay.
So we don't have to wait for we don't have to wait for the probate to complete. We don't have to wait the 6 months. She'll have the authority to sell the home. So that could be, in 2 weeks, 2 to 3 weeks right now, we can get her appointed as a personal representative, acknowledged by the court with what we call a letter of authority. And in that letter of authority, the judge will say whether or not they're going to allow Sarah to actually dispose of any assets in real estate or not. Okay. But 9 times out of 10, they do. Sometimes some judges won't. It doesn't matter that the will name the individual as a personal representative.
Mm-hmm.
They may have their reasons for why they don't want that person to just go out and sell the property. Okay.
Sure.
So in cases like that, that illustrates something really important. I think it's very important that people understand that when you have to go before a judge, whether it's a more administrative type procedure such as probate or general litigation, when you're litigating an issue in circuit court or in district court, the one factor or variable that people are not aware of and we don't have any control over as attorneys is the judge and their opinions on how things should be legally. Sometimes the judge will tell you things should be, how things should be, and it has nothing to do with legal or the law, right?
Mm-hmm.
But that's an area of control that we do not have. So generally speaking, that's when I come up with generally speaking, Sarah, if you were named as a personal representative, figure around 2 to 3 weeks, you should have authority to sell the home, but it can't be guaranteed. Now, if somebody dies without a will and Sarah goes to probate the property without a will, because there's no will now, it's very unlikely, I believe, that a judge will give her authority to sell the property. Mm-hmm. So all heirs are notified, mm-hmm. and it's determined, that there is no controversy out there. Okay. That's the difference. So good question.
Good question. Okay.